So Minnesota has a $3 million estate tax exemption. Does that mean that a married couple automatically gets a $6 million combined estate tax protection? No, that is not how it works here in the state of Minnesota. It's very important that you know this so you can protect your farm. Watch this video to learn more. Hi, I'm Jason Wagner, the farm lawyer. I work with family farmers every single day to help them pass the farmland to the next generation. So Minnesota has a $3 million estate tax exemption. That means that the estate tax kicks in when the value of the estate is $3 million or more. And we have to determine that by getting an appraisal on all of the farmland, on all of the machinery and equipment. We need to know what the value of any stored or growing crops are. We need to know if there's any contracts out there for sold crop. We need to know what's in the bank account. We need to know what the operating line is. We need to know all of that so that we can determine what is the value of the estate. If the value of the estate goes over $3 million, we potentially have an estate tax. But the story doesn't end there. First, we have an unlimited marital deduction. That means that anything going to the surviving spouse is not subject to estate tax. So Farmer John dies, he leaves everything to his wife. There is no estate tax whether he has a $3 million estate or a $300 million estate. But when we start making transfers to people other than the surviving spouse, we have now started to use our exemption. So if the same thing, husband dies or dad dies, and now the assets are going to the kids instead of to the wife, we are now going to be using a portion or all of that exemption amount. So let's take a farmer with a $3 million estate. We've done our appraisals. We've added everything up. We've subtracted the debt. What we're left with is $3 million. And that goes to the kids. Doesn't matter if it goes to 3 kids or 1 kid or 10 kids. We look at the value of the estate before it's transferred to anyone else. And if the value of that estate is more than $3 million and it's going to someone other than the spouse or charity, then we are using our exemption limit. So we've got this $3 million estate. It's going to the kids in 3 equal shares. We've completely used up our $3 million estate tax exemption. If the estate was over $3 million, every dollar over that $3 million would now be subject to tax. But in most cases, we plan to leave everything to our spouse. We leave everything to each other, right? That's very traditional estate planning. However, you do not get to automatically share your spouse's exemption limit. So if you leave it to your spouse, it is an unused exemption because we have the marital deduction. So as I said, you have your $3 million exemption, but I also said that you have an unlimited marital deduction. That means that everything you leave to your spouse is not using your exemption amount. And if you don't use it, you'll lose it here in the state of Minnesota. So what does that mean? That means that if I have a couple that comes in, and let's say they have a combined $10 million estate, and they show me their wills from 20 years ago that leaves everything to each other, say, well, you have a $3 million exemption combined. Well, what do you mean? I thought we both had a $3 million exemption. Well, sure, but you don't have any estate plan. You don't have any devices here that allow you to actually use that $3 million exemption in both of your estates. Instead, what we want to do is now create that vehicle. We don't want everything going to the surviving spouse. We want to make sure that if one spouse dies, we are using their exemption. We do that by not using the marital deduction. We do that by creating a trust for the surviving spouse, but the surviving spouse is not the owner of that trust. So if Farmer John dies, we want assets of at least $3 million to stay in Farmer John's trust. The spouse, the widow, can still be the trustee of that trust. She can get all the income off of that trust. She can even access principal if she needs to, but she doesn't own it for tax purposes. the deceased farmer's trust still owns it. That means that those assets have never transferred to the widow, and we've completely used the first spouse to die's full exemption amount. So again, let's say we have that $10 million estate, $3 million right off the bat, we're going to make sure stays in the deceased spouse's trust, Farmer John's trust. So now only $2 million is passing to the widow instead of the entire $5 million that would have been in John's name. But remember, if you saw my other videos, we can also deduct that other $2 million and get some protection there as well through the family farmland deduction. It's a very important deduction. You need to know about it. I have several videos on my channel that address it. Also on my blog, wagnerlegalmn.com. You don't want to miss out on that. So now let's say we've gone through the steps to make sure we get our family farmland deduction. So now instead of $3 million, we've also locked in the extra $2 million. So a full $5 million is protected at the first spouse's death, John's death. Everything else is in the spouse's name. As I said, it's a combined $10 million estate. She is left with $5 million in her own name. But remember, she also has her own $3 million estate tax exemption. So when the widow dies, we're going to lock in that other $3 million exemption, and we could still qualify for the family farmland deduction again at the widow's death. So now we've protected the 3 plus another 2 potentially, so that we've now gone from $3 million of protection from when that client walked in the door to an estate plan that allows us to protect up to $10 million of assets. That's a huge tax savings, but it doesn't happen on its own, and we can't do it after a person has died. This is why it's called planning. We have to plan for the estate. We have to plan for the farm succession. And if we do it properly, we've made sure that we're allowing both spouses to use their Minnesota estate tax exemption. This is a very important planning tool for Minnesota farmers. You don't want to miss out on it. You could be setting yourself up for a very painful, but also a very unnecessary and avoidable estate tax. If you like what you hear, check out farmlawyer.com, follow me on Facebook, and subscribe to my YouTube channel.